Good afternoon, everybody, and welcome to the first of the FLAC TCD seminar series on the Equal Status Act. My name is David Fennelly. I teach in the Law School in Trinity, and I'm a member of the Council of FLAC. And FLAC and the Law School in Trinity are delighted to host this series of seminars, which will take place every lunchtime on Tuesdays, and one case Wednesday over the next month. And in this seminar series, we want to mark the 20th birthday of the Equal Status Act. The Equal Status Act came into operation in October 2000, but it was some time before complaints and decisions started to be made under the Act. So even though we're a little bit past the true anniversary of the Equal Status Act, we still think that this is an opportune time to take account of developments over the past 20 years. And it's been an eventful 20 years. There have been great successes, there have been significant challenges. When the legislation was enacted in the year 2000, it was perceived to be ahead of its time in many respects and progressive compared to the position in many of our EU partners. Since then, in Ireland, we have seen significant change. We have a much more diverse Ireland. We've seen important developments in the equality area, including the marriage referendum, equality referendum, which saw Ireland being billed as a very progressive, equality-focused society around the world. But there also remain significant challenges. And of course, over the past 20 years, we've seen an overhaul of Ireland's equality architecture. And that's a topic that we're going to explore in detail in Seminar 3 in this series. And from the perspective of FLAC, a significant proportion of FLAC's casework is based around issues of discrimination. So in the context of the Roma and the Traveller Legal Service, there's a very high level of discrimination claims still today. And FLAC is also working on a number of EU-funded projects focused on discrimination, including the Equal Access Project with INAR, the Traveller Equality and Justice Project with UCC, and the new IREC-funded project with the National Travellers Forum. The purpose of this series then is to take stock. There are many sides to this particular story in the debate, and this series, I suppose, is focused on some of the legal dimensions. And in the final seminar, we're delighted to welcome Minister O'Gorman, who is committed to a review of the equal status legislation, and in particular to consider inclusion of a socio-economic status ground within that legislation. And that's a topic that we're going to return to in next week's seminar on the socio-economic status. Before we kick off with today's seminar series, I have to give thanks to a number of people who've been critical in getting this series off the ground. The series would not have been possible without the huge contribution of the FLAC team, the CEO, Eilish Barry, Chris Bowes, the Legal and Policy Officer, who's done Trojan work in putting the excellent programme together, Susan Dennehy and Caroline Smith on the communications team, and in Trinity, Sean O'Brien, who's been a huge help in getting these webinars up and running. In today's seminar, we're going to examine the effectiveness of the Equal Status Act in broad terms. And I'm delighted to welcome our two speakers on this particular topic. And we could not have two better speakers to consider this broad view on the effectiveness of the Equal Status Act. Judy Walsh is Head of Subject for Social Justice at the UCD School of Social Policy, Social Work and Social Justice, and among many other roles is the National Expert on Discrimination Law for the European Equality Law Network. And Judy's work will be familiar to many of you because she's been one of the leading Irish scholars on equality law over the past decades, and in particular is the author of the leading book on the Equal Status Acts. Sinéad Lucey is the Managing Solicitor in FLAC. She's also the Chair of the Law Society of Ireland's Human Rights and Equality Committee. And over the past 20 years, Sinead's practice over various roles and in various organisations has focused on equality and human rights. And there are few, if any, other practitioners in Ireland who have the range of experience and expertise in the coalface of equality law, the day-to-day practice of equality law, than Sinead. So we're really delighted to have Sinead and Judy with us today to share their insights on the Equal Status Act at this important point in its existence. So the manner in which we're going to conduct the seminar today is we're going to discuss a number of broad themes around the effectiveness of the Equal Status Act. I'll kick off with a number of questions, and then Judy and Sinead will share their views with us. And Judy and Sinead, we might kick off with a general question just to see where we're at this important juncture. 20 years or so on from the Equal Status Act coming into force, where do we stand? What have been the positive contributions of the legislation, and where have we seen the challenges in its operation or effectiveness? So I'm conscious that's a very broad question. Judy, I might direct that to you in the first instance, and then we'll go to Sinead.
Sure. Thanks very much, David, and thanks to FLAC for inviting me to talk today. Yeah, that's a big question. I suppose we're going to get in probably today to talking about some of probably the case law. And in fact, that the third decision under the Equal Status Act was issued on this day 20 years ago in a case concerning discrimination against a traveller couple in a pub. And since then, hundreds of decisions have been issued by the Equality Tribunal and the Workplace Relations Commission, about 1,500 decisions, I think, in fact. So we have this sort of big body of case law. And while that is very significant for reasons that we'll talk about, I think we also need to think about the effects of the legislation in much broader terms. It's sort of bigger social impact beyond looking to, this body of case law and what has been decided and where people have succeeded or why they failed. And of course, those much broader social effects are harder to quantify. We can count the number of cases and analyse them, but trying to ascertain what has the Equal Status Act delivered? Has it contributed to a culture of eliminating discrimination and enhancing equality? I think is a much more difficult question to answer. And so we might look to things like survey data on reported experiences of discrimination collected by the CSO and analysed by the Irish Human Rights and Equality Commission and the SRI. And that might tell us, well, rates of perceived discrimination haven't in fact gone down, and indeed they jumped a bit in the last cycle. But, that is qualified by the fact that people were asked about their experiences of discrimination in relation to the Gardaí for the first time in the last survey. We might also try to assess, whether organisations are attempting at least proactively to comply with the Equal Status Act outside any enforcement mechanism. Have they brought in policies, changed practices and procedures, and so to, as I said, proactively comply with the legislation? And we don't have enough data on that, I think. Similarly, we might look to, qualitative research which tries to assess whether, these measures are actually implemented in practice. Do they move beyond the tick box? We have a policy, to actually empower people to exercise their rights where something goes wrong and to prevent discrimination arising in the first place. So I suppose I guess in our discussion today, and hopefully in the rest of the seminar, we might keep an eye on that broader picture and not just fixate on the case law, because the case law is only a very partial, I guess, slice of thinking about the impact of the legislation. Having said that, obviously the case law is very important because, first of all, it enables people to obtain redress. It imposes sanctions on bodies that are found to be in default. And they're very important, obviously, for clarifying the law. We wouldn't know what exactly indirect discrimination or harassment entailed if we hadn't had a number of exceptionally usually individuals who had taken, the path towards trying to articulate their claim before the Equality Tribunal or the WRC. And I think the case law is also very important for its wider educative functions. So in other words, it signals to the broader public that these types of harms are unlawful and should be condemned and should be eliminated. And so, ECRI, the European Commission on Racism and Intolerance, has, underlined that in its guidelines for equality bodies. When it talks about them taking cases and trying to enforce the law, it really underlines that this is not just about changing the law or supporting individuals. It's about trying to communicate to broader publics, messages about eliminating discrimination, the harms of racism, classism, sexism, and so on. And I suppose in terms of Ireland, getting back to us a little bit, the fact that we do have a huge body of case law is very significant, not just for us, but also for, I think, colleagues in Europe, for example. So when I report into the European Commission system annually, very often we have a proportionately a very high number of cases to illuminate what the law means. So, 2 reports on sexual orientation discrimination and age discrimination, 2 pan-European reports, contained a large amount of case law from Ireland. And so given our size, very, very significant impact. And so I think it's important to think about that as well in terms of solidarity, illustrating how the law does or doesn't work, just in not thinking solely in terms of the impact within Ireland, I guess. So I suppose, one of the things I would say is that while we have this significant body of case law, we could better resource the WRC, I think. And that has been mentioned a bit in the aftermath of that Zalewski case, which we might get to talk about a little bit. But I suppose I would like to see a system that, reduces the caseload on adjudication officers, so that they have adequate time to grapple with what are often very complicated and complex legal provisions. I suppose, that in turn then would hopefully enhance the impact and the quality of the case law, which, as I said, is being communicated outside of Ireland to across the European Union in particular. And I suppose tied into the sort of point I made about the broader social effects of law, the goal here should always be proactive compliance, with redress or other enforcement mechanisms just as a backup. Okay. And so I know you'll be talking about equality infrastructure later on and the role of the Irish Human Rights and Equality Commission. But I think it's important to bear in mind that it is conferred with very significant powers that straddle both those two things, trying to secure proactive compliance with the law and also enforcing it in ways that don't rely on individual complaints. And I think, the Equal Status Act is distinctive, in terms of its comparator law, we'll say the Employment Equality Act, and that there is no equivalent to trade unions out there promoting compliance, supporting members, etc. And so we rely then inevitably very much on NGOs like FLAC to do a lot of that heavy lifting, grassroots type work as well. And they have done some exemplary work. So when we're thinking about activating the law, there's obviously IREC, which we might talk about later, and its powers. But there's also bodies like, the Mercy Law Resource Centre and Threshold, who are doing an incredible amount of advocacy work and activating the Equal Status Acts every single day in that advocacy work, dealing with tenants, landlords, etc. So, yeah, I suppose for me, I would like us to think about the impacts in those broader terms, while obviously mining into the case law, talk a little bit about how we might move away from an undue focus on the law and the redress mechanism provided for, towards thinking about how do we achieve systemic compliance. I think that's where we need to be going for the next 20 years.
Thanks, Judy. Sinead, we might turn to you and hear your perspective on that big question.
Thanks, David. Yeah, it is a big question. And I suppose I come from a slightly different perspective in the sense that I'm representing individual clients. And I suppose that's the experience that I absorb in my work and their kind of perspective on it. And I suppose when I was thinking about this, and we kind of take the equality legislation for granted now, 20 years later, and you can forget how radical it was when it was introduced. You suddenly gave individuals who simply had to accept discrimination as a fact of life when they went to access goods and services. They had no recourse to deal with incidents of discrimination. I recall when I was younger, there would often be a sign in shops or pubs saying, management reserves the right to refuse admission. And that was just taken as, yeah, that's a fact. I can walk in there and I can be told as a woman, well, you're not welcome in this pub, it's only for men. Or travellers could be told that travellers weren't welcome in that particular area. They simply had to turn around, walk out the door and accept that as a fact of life. So I think the transformative effect of the legislation and how it's impacted on our everyday existence, the very kind of mundane activities that we engage in, we don't think about a lot, but how that's been transformed by the legislation, and for some groups more than others. Obviously, some groups experience that discrimination, and Judy was talking about the statistics there and the perceived experience of discrimination. But the fact that somebody can experience discrimination and know they have some kind of outlet to deal with that experience is hugely important. And it's hugely important to the individual, because I think one client said to me who had an experience of a racist incident, she explained it to me that she felt it like violence. It was like a violent act towards her. And it was a very striking way of describing the experience, and not one I would have really understood. But when you see it in those terms, the opportunity to then go to a forum that's reasonably accessible, where you can look at the person across the table and have a kind of truth-telling experience and be listened to in a respectful way. You may not always win your case, but having that outlet for the individual is so fundamentally important. And I think that's what, that for me is a huge value in the Equal Status Act. So it's not only the law, it's the whole structure around the law that allows for this outlet. I suppose beyond that, then individual cases can have that ripple effect. So if we think of examples like for travellers, the individual traveller who took a case against the HSE because they couldn't access their basic social welfare payment in their local social welfare office, and they were forced off into this particularly grim, as I recall it, office in Dublin city centre, simply because they were a traveller, no other reason for it. You know, decisions like that have such a huge impact for the community at large. So I think it's all too easy to forget just how, you know, the social remedial impact of the legislation, and how we went, even if you think about the decriminalisation of homosexual acts in 1993, and it's only 7 short years later that we were looking at sexual orientation as a protected ground under the legislation, where you could actually make a complaint about how you were treated. So that's social change in attitude reflected in the legislation. So to some extent, I think the Equal Status Acts reflected where we were socially, but also led us socially in terms of reforming our thinking about certain groups in society and their experience of discrimination. So I think it's been a huge success in that regard. But recalling as well what Judy has said, has it overall led to a reduction in discrimination? Is a much harder thing to quantify and address, and I know we'll probably discuss that further as well as we go along.
Thanks, Sinead. And of course, that one's particularly tricky because as awareness grows, then, you know, people's response to service of that kind can obviously be influenced like that. So it's really interesting, and it's great to hear you both putting the Equal Status Act in its broader context, because it's so easy, you know, coming from the perspective of 2021 to forget where we're at and its major contribution at the time. And I suppose without being unduly negative, we've heard, and Sinead, that's a great example of a concrete success story that has that ripple effect of the kind that Judy was talking to. What do you perceive to have been the limitations on it in its operation over the past 20 years? Or is there anything you think could be a little bit be improved with the benefit of the 20 years of experience that we now have? Sinead, I don't know if you want to kick off on that, and then I might go to Judy.
Yeah, well, I suppose another radical kind of aspect of the Equal Status Act is that it applies to both in the public service statutory bodies, etc. So public services and also private providers of goods and services. And that's obviously a very positive aspect of the legislation. So the example I gave was around accessing a social welfare payment. But I suppose one of the biggest limitations that has emerged in the case law, and which is evident in the legislation, is the blanket exemption around an act that is required to be done pursuant to an enactment. So that's section 14 of the Act, and that has figured quite prominently in the case law. And I know Judy has done very considerable research around this and can probably speak to it much more knowledgeably. But it strikes me as a very uneven, an uneven coverage where the private sector actually bears a heavier burden under the Equal Status Act, if I can, or bears a higher responsibility is probably a better way of putting it, than the public sector. So either the state, I suppose the state can essentially legislate itself out of this requirement not to discriminate against members of the public across the 9 grounds, and that seems to be a huge gap. And I think some of the case law there, and just to reflect on a very recent example of that around a woman, an asylum seeker, and I think David, you had some involvement in this, but you know, a woman seeking a provisional driving license and being refused the driving license on the basis of her residency status in the state. And that was found to come within the scope of section 14. And therefore she had no means of redress for that particular incident. And that just seems to me, it's very hard to justify that very broad exemption without even the state having to really even justify it before the court. So without any justification, can simply rely on the legislation and then say, well, it doesn't bind us and it's not held accountable for that. So I think that would be one of the major weaknesses, I suppose, in the legislation that's emerged.
Okay, thanks, Sinead. Judy, any thoughts on that?
Yeah, I would absolutely agree with Sinead's point there. Yeah, there's been a large number of cases which have failed for precisely that reason, because the treatment in question was considered to be required by law. So things like people seeking eligibility for medical cards, tax credits, statutory pensions, child benefit payments. And yeah, I mean, the law is intricate and complex, and there's a lot of cases deciding what precisely is required, by including the case that Sinead mentioned from the High Court recently. But I suppose the broader point is, as Sinead said, you know, it in a sense means that there's a less of an onus to comply with the legislation on the public sector, and it's arguably, I would say strongly argue, that it's incompatible as well with the EU race directive, which overlaps with the zones covered by the Equal Status Act under Irish law. So I'd imagine, I mean, I think the exemption should be absolutely analysed at this stage by the government. But I would also say that there's a prospect of it being challenged, at least as it applies to the traveller community and race grounds, before the WRC indeed, because now you can directly challenge the applicability of an Irish provision before the WRC. And so I would envisage some challenges perhaps being taken. If there's anyone out there trying to do strategic litigation, please give me a shout. On stuff like laws that apply in particular to members of the traveller community in relation to evictions, for example. So there was a case called O'Donoghue and Clare Council back in 2018, in which you can see the kind of all of the limitations, I think, of the Equal Status Act, and the one that Sinead just described in play, the Section 14 exemption for treatment required by law. So the family concerned couldn't challenge the fact they were issued with notice to move on when they were living on the side of the road. They couldn't challenge the the implementation of the County Council's traveller housing accommodation policy, because it was considered to be a measure that applied exclusively to the members of the traveller community, etc. So, you know, absolutely, Section 14 definitely ripe for review, and it may be that we end up with a reference to the Court of Justice of the European Union if that doesn't happen. So it'd be good to see some, I suppose, proactive moves on the part of government in that regard. And related to that as well, I suppose, there's a broader issue about just the need to clarify, I think, the scope of the legislation in that sense, to explicitly state that the law covers social welfare and what are called social advantages under EU law, because the tribunal and the WRC have had to interpret, you know, those provisions of the Act over and over again. That's given rise to some very complicated case law. So this definition of service, I think, needs to be revised. It needs to be rendered more clear. And, you know, and in a lot of cases, the Section 14 exemption, and then whether certain functions of the state or of public bodies fall within the definition of a service are contested together. And so, you know, we know, for example, that because of the definition of service that we have at present, things like policing aren't amenable to being scrutinised under the Equal Status Acts. So in other words, allegations of discrimination in the course of the investigation of a crime by the Gardaí, or them enforcing a child care order, etc. You know, and there's again a lot of difficult case law there about what precisely is a regulatory kind of function that's not a service, what is a public service. We could talk about that all day. But again, I suppose the bigger point is a need for greater clarity, you know, at this stage of time, to have a look at the exemption, and in tandem with the exemption, have a look at aligning the definition of service with what's required under European Union law in particular.
Thanks, Judy. And I must say, I'm struck by that in my own experience. Before you even get to the substantive discrimination issue, oftentimes there are threshold issues which themselves are extremely complex and difficult to overcome. Yeah. And I suppose also that the acts don't sit in isolation. The relationship between, for example, the acts and the race directive, which you mentioned, but that's not entirely straightforward in the way in which we've legislated for it. And also the broader question that you and Sinead both raise about, you know, equality protection vis-a-vis the public bodies, and of course the constitutional piece of that as well, which remains quite underdeveloped, I would say. Turning to the grounds, the protected grounds under the legislation, my sense is that the experience has been quite uneven across those grounds. So we've already heard reference to a number of, you know, quite prominent challenges under various grounds. What's your impression of that? What stands out over the past 20 years where there's been good steps forward in providing protection against discrimination on the various grounds, or where have we seen kind of weaknesses or gaps? Sinead, I don't know if you want to kick off on that one.
Yeah, I suppose in thinking about this, I suppose two grounds stand out for me, and one where there's been a bit of innovation, and that's around the gender ground and the extent to which it protects, I suppose, somebody's transgender identity. And it's kind of, again, another success story under the Equal Status Acts, that transgender individuals have managed to be protected somewhat, you know, not completely, somewhat awkwardly, maybe stretching certain definitions there, but bringing themselves within the gender protection and disability protection. And that's been really positive in terms of that community. The other ground, and all of these grounds, there have been gains and there have been disappointments, I suppose, within it. So another example that strikes me is around disability and the definition of disability. Again, I think that's another success story of the Equal Status Acts, because the definition of disability has been left quite broad and inclusive. So it doesn't create some kind of hierarchy of disability. It includes, less obvious disabilities like somebody who might suffer from agoraphobia. It mightn't be something that you see, but it's a very real experience for the person. And that has to be taken into account by service providers. So I think on the disability ground, there have been significant gains. I suppose where it's come up quite prominently is around education. And there's been quite a large number of cases taken around what might be termed kind of special education provision. So I suppose one very positive case is around the fact that if you were attending a special school at one point in time, if you reached your 18th birthday before you had completed your leaving cert, you were literally dumped out of the system and you couldn't actually complete your leaving cert, which seems quite shocking now. But obviously that was successfully challenged under the legislation. But I think a lot of areas around special education and provision of reasonable accommodation remain unchallenged within the education system. And I think one of the most disappointing cases in that would be Cahill and the Minister for Education, where there was a positive system of accommodations for persons with dyslexia, in terms of how the Leaving Cert was examined and addressing the particular difficulties that might be experienced by somebody with dyslexia in completing, dealing with grammar and written work. And so that special accommodation seems to me to, on the other hand, have been swept away by the fact that the Leaving Cert then gets annotated in that way, disclosing the person's disability and suggesting in a way that the Leaving Cert isn't quite the Leaving Cert that everybody else has gained. So I think those kind of grounds strike me. I think for the traveller community, one of the biggest disappointments was a lot of the initial gains around challenging licensed premises, and the success that was achieved there was then reversed in 2003 by the removal of the jurisdiction from the Equality Tribunal at the time to the district court, so that complaints around licensed premises, complaints of discrimination in licensed premises were moved to the district court, which on any day is a much less accessible forum than the Equality Tribunal or the WRC is. So I think it's a huge disappointment that what was a success story under the legislation was swept away. So I suppose, like everything, there have just been gains, there have been disappointments, and this links back with what Judy was saying, is that we need to look at the legislation now and look at how it needs to be changed to address those issues where it hasn't quite addressed the full range of experience of discrimination.
Thanks, Sinead. Judy, any thoughts on what stands out for you when it comes to the...
I suppose, so kind of early in the arc of the legislation, there was some fantastic decisions actually issued by the Equality Tribunal, really elucidating kind of tricky concepts like, can you take a case of direct discrimination where there's no actual person in a similar position to you that you can compare your treatment with? So this idea of a hypothetical comparator, you being able to argue that, well, I've been treated less favourably than somebody else would have been treated. So there's a fantastic case that goes back almost the full 2 decades, O'Brien and Éireann Rud Éireann, which was a traveller ground case in which a woman travelling on a train was accused by a fellow passenger of stealing something, and the respondent, right, the Éireann Rud Éireann staff called the Gardaí immediately, and this woman was taken off the train and questioned. And they simply said, this is direct discrimination on the traveller community ground. This person was treated less favourably than a settled person would have been. And they reasoned through that by saying, well, this is a complete departure from standard practice. What would you normally expect to see happen in a situation like that? You would expect this issue to be dealt with discreetly. you would expect, a modicum of dignity and respect to have been afforded to the individual concerned. So, and that case then was a similar case called McGrail Included Housing, in which a man living in housing that was provided exclusively to older people was similarly able to argue that his eviction after a period of 4 weeks' notice was a similar departure from standard practice. So again, although there was no actual younger people he could have compared his treatment with, the tribunal was able to find, well, a younger person wouldn't have been afforded that treatment, that age was a factor in the, pretty loose, I suppose, or harsh application of eviction procedures. So, yeah, there's been some really great case law early in the arc. The extent to which that, I think, is carried through and we see it being used now is probably in question. I would say a lot of the flagship cases for me have been on the traveller community ground. Another case of Berry versus Dublin City Council, which similarly tries to get around that issue of how do you argue that you've been treated less favourably. That concerned a 6-month delay in repairing a sanitation unit that had been damaged in a fire. And again, very successfully, the people were able to argue in that case that the failure to repair on the part of Dublin City Council was on the traveller community ground, that a similar delay would not have been experienced by people in other local authority housing. So, yeah, there's been some great, I think, again, in thinking European terms, really, really good decisions that really clarify the law and hold a lot of potential, I think, for applying it in various circumstances where it may not be evident that there is discrimination happening. The housing assistance ground, the introduction of that, I think, is looking to more recently, is exceptionally positive. First of all, because it is tackling a form of very widespread or systemic discrimination, according to IREC. And it is successful in the sense that there is a huge number of cases on the ground, and so it's far outstripping now any of the other 9 grounds in the area of the Equal Status Act. So I think that has been very welcome, and one of the few kind of, I suppose, substantive changes to the law that's come out of, that hasn't been compelled by the European Union, but has been a response to broader social injustices. So, yeah, I think the introduction of the housing assistance ground is exceptionally positive. Although, again, what's required by landlords is modest. I suppose reasonable accommodation, Sinead has touched upon. Again, that is an area at this stage that we really need to reform. Since the Equal Status Act was introduced, we've had the adoption of the UN Convention on the Rights of People with Disabilities. I know there was a bill introduced in 2016, which purported to amend that section, and I think that's urgent at this stage, because it isn't really fit for purpose. There's a lot of ambiguity around how it applies. Sinead has mentioned the Cahill case. There's difficulties, I think, in how it's been interpreted as well by the WRC. I think there's, again, in light of the principles that are set out in the convention, it needs to be interpreted in a what's called a purposive manner, to think about it. What's the purpose here? The promotion of people's dignity, respect for people, etc. So a lot of the cases sort of fail because for technicalities, and there's not this kind of need to imbue it, I think, with a greater spirit or sense of what we're trying to achieve when we're thinking about non-discrimination. There's been some good decisions on reasonable accommodation as well, requiring schools to be proactive in terms of seeking out supports for children with disabilities, adjusting things like disciplinary procedures so that they take account of people's disabilities. But again, to what extent are is this really being reflected in changes in practice, I think, is something that Sinead has brought up there. Something that's kind of technical, but again, on my shopping list, victimization is. So this is, at the moment, this is actually technically a ground of discrimination under the Equal Status Act, and I think that has to be changed. There's a huge lack of clarity. You can see through all the cases, people invoking it and trying to say I was being victimized, when really what they're claiming is I was being bullied, in effect. So victimization is a very specific harm, which in effect, you might call it retaliation. So you try to invoke your rights or help somebody else to invoke their rights under the Equal Status Act, and you're subjected to retaliation by the service provider for doing so. It's a mess. The case law is a mess. And then, I think there's several cases, especially in the area of housing assistance, where I've seen what are very extreme examples of victimization happening, but the complainants haven't raised it, apparently. So, in other words, people being evicted when they have tried to get their landlord to sign the a HAP payment form and so on. So I think victimization is another area that could be strengthened, and certainly the way that it's set out in the legislation at the moment is confusing and completely unsatisfactory and out of sync with the EU law again. So yeah, I mean, yeah, definitely. Like I suppose certain grounds have there's been really good case law on certain grounds. Some I think are relatively neglected. So if you think of something like sexual orientation discrimination, maybe 10, 15 cases, but nearly all concerning sort of private service providers, hotels, accommodation providers, and so on. And yet we know from data that children in schools experience bullying and harassment related to their sexual orientation in very alarming levels and rates. So again, there's a disjuncture there between what I suppose research is telling us and what we're seeing coming through in terms of the case law. And obviously there are very good reasons for that as to why people aren't, who are being bullied at school aren't taking cases to the WRC or the tribunal and so on.
Thanks, Judy. And I mean, there's one, and it strikes me, and this is something we might come back to again, but of course, looking outside the individual grounds is the challenge of intersectional discrimination, and that's a bigger challenge for all equality regimes, and it's something that we need to consider as well. Turning to the procedures under the Equal Status Act and now under the Workplace Relations Act as well. Our friends in CLM have recently produced 2 handy guides to the Equal Status Acts and the Employment Equality Acts, which are very useful resources. For those of us who kind of practice in this area, we know that the legislation is intended to be quite informal in its approach, but the reality can be a little bit more challenging. Sinead, do you have any thoughts on how effective the procedural framework for equal status claims is?
Well, the procedure differs somewhat in terms of equal status claims and then employment equality claims. So there is a prior requirement under the legislation to send a notification to a potential respondent to a discrimination claim. So within 2 months of the alleged incident of discrimination or the most recent incident of discrimination, there's a legal requirement to send a notification which includes certain particulars in the notification to the respondent and to seek a response from the respondent. So you have to outline what was the particular incident and indicate to the respondent that you intend to go on to lodge a complaint with the Workplace Relations Commission in the event that you're not happy with the response that you receive. Now, I suppose saying that, it sounds like, well, that's not a big burden on anybody just to send a simple letter and set out those matters. It has become a bit of a booby trap for a lot of potential complainants under the Equal Status Act, who for one reason or another, it could be connected with literacy, lack of awareness, lack of information around the legislation, either don't make the 2 months time limit, and I can't think of a single other legal process that requires you to comply with such a tight time limit, or they fail to mention, that they will go on to the Workplace Relations Commission or that they'll refer a complaint. They don't describe it properly as discrimination on a particular ground or whatever. And so immediately when the complaint comes for a hearing, there's this initial threshold issue around, was the notification requirement fulfilled? Now, my understanding, if you look at the legislation, was the notification requirement was meant to allow a respondent to have an opportunity to have some kind of response to the incident. It wasn't really intended to become this barrier to the ultimate complaint, and often the respondent isn't really prejudiced because the notification wasn't exactly within the 2 months, or they often have the opportunity to respond even after a complaint has been lodged. There's no barrier to the respondent making a response to it. So that's one of the procedural elements, and just to reflect on one particular case that FLAC has ongoing at the moment that picks up on some of these issues, because it involves An Garda Síochána and the experience at an immigration checkpoint in the airport. And obviously that's a question whether that function comes within the Act. But the other thing is compliance with the notification. So in looking at this case, we went through with the assistance of the Equinet organisation, which coordinates between equality bodies, and to find out from those equality bodies, is this notification requirement required in any other EU state operating under a similar regime? And the answer that came back was no, Ireland seems to be wholly unique in this particular requirement. So it really seems unjustified that somebody's very profound complaint of discrimination could not be considered simply because they didn't meet this notification requirement. I suppose another procedural issue now is the complaint form itself. We're 6 years on from the establishment of the WRC, and as yet there is still no dedicated complaint form to deal with the equal access or equal status complaint. So you actually have to fill out a complaint form that is designed around employment complaints, and it is highly confusing. Now, as a practitioner, I'm used to the form and I know how to tick and get around the various ticks you have to put in a way that gets me through to the end of it. But I would be very concerned about somebody that doesn't have representation, is not familiar with the particular form, it maybe doesn't use IT a whole lot, etc., and they're forced into this online platform that suggests to them that the form isn't actually directed towards the complaint they want to make. And there are other issues, but I'll just create space there for Judy to come in as well.
And Judy, I might ask you you mentioned quite rightly the importance of looking beyond individual redress, but how effective do you think the remedies are under the Act, as well as the procedures, perhaps?
So there's two, I suppose, broad types of remedy. There's, first of all, monetary compensation up to a ceiling or a maximum of €15,000. And then secondly, there's a very broad provision that enables the adjudication officer to direct that a course of action be taken by the person that has lost the case. So first of all, compensation. Arguably, the €15,000 ceiling should be removed because it's not compatible with EU law. Here I go again. But I suppose more importantly, and equality officers and adjudication officers have pointed this out in quite a few cases, that it's not an adequate sum to actually, account for, to redress for the harm that has been experienced in some cases. So we're seeing that really, I think, coming through in a sharp way with the housing assistance cases, where you can actually quantify in monetary terms the damage that has been caused because of lost housing assistance payments. So you have several cases with €12,000, €10,000 lost in half payment, and then what you do about the discrimination element of it, the compensation for the harm, distress suffered as a result of discrimination. In some of those cases, people have been rendered homeless or at risk of vulnerable to homelessness. So this is really, really serious stuff. Similarly, back 10 years ago, you had equality officers commenting on the fact that children who had lost school places, a whole year of education because of discrimination in school admissions, couldn't be compensated by what was then the threshold, monetary threshold. So that's something that has to be looked at. Secondly, the order for a course of action is a really good and innovative feature of Irish law. I think that's something that we, are leaders on in European terms. Other countries look at it with envy. But again, it's a question of, and there is some ambiguity here as to the precise parameters, what's exactly is possible, because it is so open-ended. What precisely can you direct a respondent to do? So we see adjudication officers routinely directing respondents to do things like ensure that somebody can access the half payment, for example, but also going more broadly to direct them to institute training on the Equal Status Acts, to equality proof their procedures and processes. So last year, for example, there's a really good case again in the housing assistance ground in which precisely that was ordered. Go and equality proof how you deal with your clients and customers, report back to me within 3 months, and then within 6 months I want to see all these actions implemented. So that is a really great tool. And again, is something when we're thinking about that systemic effect, as you said, David, is absolutely crucial to the success of the Equal Status Acts and to what Sinead was saying earlier, capitalising on the impact of individual cases so that they have much more widespread effects on organisations' policies and practices. I would say it's underused, but that's me. Compensation is by far, the most common remedy awarded, but there are some very good examples there, which again could be, I think, developed further.
And another element of that jigsaw strikes me is, of course, individuals for all sorts of reasons in this area may not want to take on a daunting claim, even if it is before the WRC and not before the court. On. And one development we've seen across so many other areas, consumer law, data protection law, very prominently in recent years, is the role of representative action. And that's something that we haven't really seen develop in the same way here, notwithstanding the evident need for it. Sinead, any thoughts on how we might tackle that particular challenge?
Well, I suppose representative actions in terms of equality law certainly aren't unknown, and there are examples in other countries where NGOs, civil society organisations, are enabled to take equality complaints on behalf of the people they're advocating, and there are some high-profile cases emanating from that. A lot of the times, the individual person may not be in the best position to take the particular case, or sometimes the discrimination is so generalized that there's no one individual can identify themselves as the victim, albeit that there is this generalized discrimination going on. So I definitely think within the legislation, I mean, it is arguable that it is possible to take a representative action despite decisions, previous decisions around the gay choir and more recently an association for deaf people. But I think it's arguable that is a possibility. And again, that's strategic litigation. IREC has that power to take a representative action in its own name, but I wouldn't see a barrier to an express amendment to the legislation allowing civil society organizations or NGOs to take representative actions. And of course, they're going to have to prove the discrimination like everyone else. It's not that it's going to be this abstract case coming before the WRC, but it certainly takes the burden of the individual, and it also allows unaddressed instances of discrimination to be at least examined under the legislation and some kind of finding made about it. Yeah. So it's certainly something that should be considered.
Thanks, Sinead. And one of our guests today points out that under Section 23 of the Equal Status Act and Section 85 of the Employment Equality Act is provision for such actions as you alluded to there. Thanks for that. Just to wrap up then, and I'm conscious we have a few questions coming in, and I'd like to leave a little bit of time for that. Looking to the future, Judy and Sinead, what do you consider, and just another very difficult question to end on, what do you consider the area of most untapped potential or the area for further development that you'd like to see progress on over the next 20 years? So Judy, I might kick off with you and then I'll go to Sinead.
Yeah, so I think I would look to the kind of, as I mentioned at the start, the sort of broader compliance and enforcement mechanisms, and that's something that you'd probably deal with in that seminar. But, for me, one of the kind of better developments over the last sort of 5 years even has been the Irish Human Rights and Equality Commission activating its power to conduct equality reviews, or rather to invite organisations to conduct equality reviews. And again, we're thinking about this, systemic, trying to get at systemic or ingrained discriminatory practices. That is the way to go, not to place the burden on an individual to try to challenge it in a limited kind of fact scenario, but to have bodies like IREC look across the board at an organisation's policies and practices, engage with them with a view to changing them. So they have instigated several of those reviews just in the last couple of years, and the very limited information in the public domain about how those are working out, apart from I guess, you know, the recent discussion in the national media of Bank of Ireland and subsequently other banks changing their practices around enabling international protection applicants to open bank accounts, and that was on foot of one of those equality reviews. So I think that I would like to see more of that happening, more of the systemic provisions being invoked, the facility that Sinead mentioned for IREC to take refer cases where discrimination is being widely practiced against persons in an organisation is something that could be activated. The Equality Authority took a couple of those cases some time ago in the context of harassment and sexual harassment, I think. So there's precedent there. The Public Sector Equality and Human Rights Duty, of course, is a very important development. The Equal Status Act is part of that. Again, thinking about proactive compliance and reducing the burden on individuals to try to enforce the law. You know, it places an onus on public sector bodies to proactively assess, address and report compliance with anti-discrimination law, including the Equal Status Act. So I think they're the things that I would see going forward. The case law, you know, there's so many, I suppose, individual bits, but something that has been underused, I think, is the indirect discrimination provision. Again, for very good reasons, because it's highly complicated, very, very difficult to put a case together. Harassment as well, I think, is another area that there's more potential to develop the case law on. I'd say that's it now, because we're running out of time.
Judy, and we're kind of running short of time. Sinead, any further thoughts on that big question?
Yeah, big question. So I think the WRC has to do a lot of work to give prominence to the Equal Status Acts within its structures and make it more accessible. Another thing that strikes me is there is no legal aid for taking equality cases at first instance, and there are very few legal practitioners in the area. So I think it would be good to see the state empowering different groups and communities to act as advocates for themselves and to self-support, I suppose, in a way, in terms of taking those individual cases. And what I mean by that is providing, I suppose, funding to provide education to raise awareness of the legislation, because I think awareness has definitely dropped of the legislation and its potential, and to make advocacy services accessible to individual victims of discrimination in taking their case. It's not always going to be possible to get a solicitor to take your case, and it's not always necessary. But the communities that experience discrimination really need to be empowered to take ownership of this legislation. It's there for them, and they need to be part of that kind of narrative around it in terms of promoting its use and supporting those they represent to use the legislation, and then promoting the outcomes. Obviously, IREC has a role there as well, but I think there's something about the grassroots organisations also being empowered around the legislation. It's meant to be accessible, and that's where people access those supports, those services.
Very good. Thanks, Sinead, and thanks, Judy. We've got a few questions just coming in and a few thank yous as well. Just one specific question. I might just run through the questions very briefly in the interest of time. The exclusion of self-employed people over 66 from the PUP. Sinead, any thoughts of that under the Equal Status Act? Challenging one. Somebody asked about the extent to which organisations such as GSOC are subject to the Equal Status Acts. And there's also a question about the lack of support for persons with disabilities, for example, in the context of accessible toilets in pubs, and the extent to which the Equal Status Act can contribute in that respect. Sinead, any thoughts on that first question? And Judy, I might come to you on the other two, if that sounds okay.
Yeah, so the exclusion of people over 66 from the PUP, I think this comes back to something we were saying earlier. So clearly there's age discrimination there, but is it a form of discrimination that could be defended by reference to Section 14? It's debatable. I mean, the PUP is now on a statutory footing. So I would think on balance, probably any exclusion that has a statutory basis is unfortunately going to be defended by the state on that basis. But for the period that it wasn't on a statutory basis, there might have been more potential for a challenge there. I think the next question was whether GSOC is included. Well, I would have thought, yes, that they're certainly not excluded. I think the question around policing is usually whether on Garda Síochána are included in the legislation. Certainly there is a justification for including on Garda Síochána. Why should any public body be allowed to discriminate without redress? But I don't understand that GSOC is excluded or would have the same arguments to be excluded in the service aspect of what they do.
Very good, Sinead.
Yeah.
And just that final question then about the lack of support for disabled persons and taking cases with the example of accessible toilets in pubs and so on. Any thoughts from either of you on that important question?
Well, I might leave that one to Judy.
So I suppose, well, in terms of lack of support, I suppose, yeah, there's that practical, obviously massive consideration about how you go about what kind of advocacy services are available to enable you to take those types of cases, especially given that if you're talking about a pub, you're talking about taking a case to the district court because of the change that we mentioned earlier as being problematic. And then there's the kind of limits, I guess, again, of the reasonable accommodation duty, which that would fall under. You would be getting into things like, so it's a reactive individualised duty. It's about enabling somebody to access a service there and then, as opposed to general accessibility standards. And so, the relationship between those two, I think, needs to be further examined again in light of the UN Convention on the Rights of People with Disabilities. But if you were to mount it as a reasonable accommodation case, you would run into things like the nominal cost issue. And this, again, is where I think we need to, as I said earlier, that is a major, I think, almost invisible barrier to invoking the Equal Status Act. One of these kind of preemptive things whereby somebody hears about the nominal cost threshold and says, oh, well, installing a bathroom, an accessible bathroom would impose more than nominal cost. But in fact, that is relative to the resources and capacities of the organisation. It depends on whether there are grants available to do so, etc. So it's something I'd love to see being activated and pushed for, because I know myself from trying to organise meetings and conferences, it's a massive issue. And you've got ostensibly accessible bathrooms that aren't in fact accessible as well. Brilliant. So yeah, big questions there around enforcement.
And unfortunately, due to time, we won't be able to explore them further. But Judy and Sinead, thank you so much for the tour de force, bringing us through the past 20 years and sharing your real insights on the Equal Status Acts. And thanks also to the people who've asked the questions and all of our participants. Sadly, time has beaten us today. We're back next week, same time, same place, for the second seminar in the series, which will look at the socioeconomic status, and we'll be joined by Paul McKeown, Thomas Kadar, and Siobhan Phelan, I see, for that session. So without further ado, thank you very much to everybody for joining us today, and we look forward to seeing you again next week. And thanks to all the team at FLAC and Sean O'Brien and Trinity for their assistance with the seminar.
Thank you.
Thank you.